ASIC's enforcement regime for disclosure obligations operates as a hybrid and deterrence-based model. Although ASIC claims to follow responsive regulation, enforcement in practice is proactive. Empirical evidence shows that enforcement is typically incapacitative at the apex of the regulatory pyramid. Individually, breaches of the duty of care and diligence under Section 180 is most relevant to disclosure and carries no criminal liability. Under the Corporations Act, directors' duties are owed to the company, but they are usually enforced by ASIC or a liquidator. ASIC can act for the company under Section 50 of the ASIC Act, and they may pursue criminal penalties under Section 184 for other duties but not Section 180. At the company level, continuous disclosure obligations form a hybrid regime where Listing Rule 3.1 is given statutory force through Section 674. Companies must immediately disclose any information that a reasonable person would expect to influence the price of securities, and failure to do so attracts penalties. In sum, ASIC's enforcement is a dual strategy of pursuing corporates under Section 674 and directors under Section 180. The initially responsive regulatory design has been usurped by a deterrence-based approach. The STAR case study shows how ASIC pursues directors for breaches of duties to influence governance behaviour as part of this dual strategy. In 2018, STAR director Hawkins approved an agreement with Sun City despite knowing its representatives exposed STAR to legal and licensing risks. He did not report media coverage or internal concerns to the board or recommend ending the relationship. In 2019, Theodore allowed misrepresenting correspondence to be sent to the NAB. Hawkins was fined $180,000 and disqualified for 18 months, and Theodore was fined $60,000 and disqualified for 9 months. These were governance failures. Both directors failed to question, escalate, and act when compliance risks were clear. The decision shows how Section 180 functions as an individual enforcement mechanism to promote vigilance and director accountability. Some warn that such enforcement may encourage defensive governance, where boards act out of fear of liability. The AICD's Directors' Liability Report identifies Australia as the high watermark for director exposure around the world. This risks pushing directors towards compliance micromanagement, contrary to Australia's principles-based approach to corporate regulation. As ASIC Commissioner John Price observed, the board must set the tone, influence and oversee culture, and ensure that the right governance framework is in place. In STAR, a failure to escalate compliance and reputational risks had drastic consequences. The ASX and ASIC frameworks are highly detailed in prescribing market disclosure processes, yet the same level of structure rarely applies to internal disclosure systems. A board-level disclosure committee should oversee both ASX announcements and the internal escalation of market-sensitive issues. Clear internal reporting lines and documentation would ensure that issues reach the board in time for intervention. Executives and directors should also receive regular training on identifying and escalating risks that is consistent with ASX and ASIC expectations. By applying market disclosure discipline to internal governance, the board can prevent the kind of communication failures that occurred in STAR, reducing regulatory and reputational risk.